Case number 107987, State of Kansas v. Pfannenstiel.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing this morning on behalf of Ryan Pfannenstiel. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, there are two issues in this case. The first issue, this is an aggravated sexual battery case out of Sumner County. And the first issue has to do with failure to give a lesser included offense instruction. And the second issue has to do with procedural propriety when Mr. Pfannenstiel was raising claims of ineffective assistance of counsel against his trial attorney. The first issue in this case has to do with the failure to give a lesser included offense instruction. This was charged as, and Mr. Pfannenstiel was convicted of aggravated sexual battery, and the claim in this case is that the district court should have given a lesser included offense instruction for sexual battery. As recognized by the Court of Appeals in this case, the only difference between these offenses is whether or not the victim is unconscious. If the touching takes place, that sexual battery, if the touching takes place when the person is unconscious, it's aggravated sexual battery. The Court of Appeals correctly did the analysis from Williams and found that, of course, sexual battery is a lesser included offense of aggravated sexual battery, so it would have been legally appropriate to give this instruction. Your Honor, I would also note that clearly the evidence would have supported a conviction for sexual battery in this case, and therefore giving that instruction would have been factually appropriate. The question we're left with then, and really sort of where the Court of Appeals got stuck on this, is whether it would have been clear error because it wasn't requested in this case, and therefore whether it should be reversed in this case.
Is that our test? The evidence would have supported a lesser? Is that our analysis?
That has been your analysis in other cases, Your Honor, with regard to factual appropriateness.
Right.
And Your Honor, that's the right test. The idea being that so long as the jury's verdict would be a valid verdict, then it's factually appropriate to give that instruction. So we have to look at the circumstances in this case and find out whether there's a real possibility that the jury could have come back with this lesser in order to determine whether there was clear error in this case. And there are a couple points that I would bring the court's attention to. First of all, the facts themselves. And as I reviewed the facts in this case, it was, I thought, important to note that the victim in this case is relating the sensations and the things that she's claiming is the crime in this case. She was awake.
When did the touching occur? When do we start? Because both the victim and your client say she was asleep when he first approached her. And is that the beginning of the crime, when he first has contact with her? Or is the only point we focus on when there was the kiss or the whatever on the arm?
For sexual battery or aggravated sexual battery, we have the touching that we have to be dealing with has to be the touching that is with the intent to arouse, to be the sexual battery. That has to be, and the unconsciousness has to be contemporaneous with that. It can't be the case that you're unconscious and then you wake up and something happens.
Why can't it if it's a continuous act? I mean, all of those things lead to your client being able to accomplish what he wants to do. Assuming a sexual intent, isn't all of that a continuous act?
Yeah. Well, I don't know that you can assume the sexual intent, Your Honor. I mean, there's no evidence of touching with the proper intent.
Right, but I'm just asking
while she's asleep. That's the thing. If you assume that, that would be sufficient evidence to support the aggravated sexual battery conviction. I'm not saying there wasn't sufficient evidence. The question, though, is could a jury reasonably have form a reasonable doubt with regard to whether it occurred at the entire time? And that's really the claim here. And the question for the court is, could a jury in this case, under these facts, have formed a reasonable doubt whether or not the touching took place while she was actually unconscious?
Well, the sexual battery touching. I don't think there's any question that he touched her to wake her up. Isn't your argument that he touched her to wake her up and that she was awake then when the alleged, with intent to arouse touching occurred. Isn't that your argument?
Your Honor, the answer to your question is the facts are convoluted in this case. So my client's testimony was he was in there and touched her. My client never admitted to touching her with improper intent. And so you lay that aside. And then there are other facts, as is often the case, right? That there are different perspectives and different witnesses. And you have the victim's testimony. But the victim's testimony in this case is she was conscious when she heard somebody in the room moving around. She thought it was her boyfriend or partner or whoever. And then she felt this other touching on her arm, which I think was the subject of the state's sexual battery charge. So I don't want to suggest that we were admitting any sexual battery, but you have these competing theories, and that's the point. In these, when you have all these competing theories, could a jury have formed a reasonable doubt whether she was unconscious when whatever the state did show as far as improper touching took place? We're bolstered in the claim that they could have because we know the jury asked questions specifically about aggravated sexual battery in this case. Even after the judge gave the definition, the jury asked, can you please define aggravated sexual battery? And the judge said, no, this is the best I can do. And then we know the jury came back with a very odd verdict in some ways. Because if the jury believed the victim completely in this case, why did they acquit my client of aggravated burglary? So there's a split verdict in this case. And so all these facts, I think...
They could have acquitted if they thought he was invited into the home.
Sure, although she unequivocally said, I never invited him into my home. I'm obviously speculating a little bit, Your Honor.
On that one.
I'm just putting it out there as maybe it's a compromise verdict. That's, I think, a reasonable explanation at least. And if that's true, then had the jury been given another option on the very count that they asked a question about, isn't it really possible that they might have taken that, especially in light of the evidence that she was conscious when she was perceiving this touching? On the second issue, Your Honor, which has to do with Mr. Von Steele's claim before sentencing that he had received ineffective assistance to trial counsel, our claim in this case, Your Honor, I just want to be clear, is that because of the way the case proceeded, either the trial judge shouldn't have entertained these claims at that point or should have appointed new counsel for my client. The judge in this case took the inappropriate road of essentially having Mr. Von Steele's attorney testify against him. The Court of Appeals disagrees with my characterization in that point, saying that there was no evidentiary hearing. I'm reading from volume 14. This is at page 7. And this is after a colloquy with my client where the district court asked Mr. Von Steele, well, what are you saying happened? What are you saying happened? What are you saying happened? And then page 7, court says, Ms. Esparza, did you contact any of these witnesses? And the trial attorney then disputes all of the claims that my client made. And similarly at page 17, after the district court has had a colloquy with Mr. Von Steele about some of his claims, he turns and says, did you send a copy of that evidence to the defendant? Now, I'm characterizing that because I believe that is the district court seeking information from a person. And so, yes, I characterize that as an evidentiary hearing, that the district court is gathering evidence about claims that my client made, and that in that situation, that is an evidentiary hearing, and that in that situation, my client was left without an attorney, that his attorney was testifying against him, and that that's inappropriate. That's a conflict. Every defense attorney should recognize that.
Counsel, how do you reconcile that with the direction of the United States Supreme Court in Mickens and other cases of this court where we have given the trial court an obligation to inquire when a conflict of interest is raised?
I think the inquiry into the conflict of interest is sort of, and to that extent, if you go, okay, we are inquiring, if this is an inquiry into the conflict of interest, the end result should have been, well, apparently we have a conflict of interest because you're testifying against your client. And even Mickens recognizes that there's a conflict, an actual conflict of interest when the attorney is acting against their client's interests, which is exactly what this attorney was doing.
And how do you classify this motion? I mean, in your Court of Appeals brief, I think you referred to it as a 1507 motion.
I classify it, I don't know how I classify it. Standing here, I would classify it as a motion for a new trial based on ineffective assistance of counsel. Certainly that was the gravamen of the client's claims here, that the attorney had failed to call witnesses, that the attorney had failed to make arguments and bring out certain evidence. Your Honor, when a defense attorney understands that their role, sometimes the court will ask them questions and they have to honestly answer those questions. But when that happens, they are suddenly not able to be an attorney anymore for that client because they are being called upon to testify against their client. And when that situation happens, the district court shouldn't be able to proceed then on the merits because that client is essentially left without an attorney. If this court otherwise affirms this conviction, we would ask that this be remanded so that conflict-free counsel can be appointed for Mr. Fonsteel and the court can proceed on this motion.
Any more questions?
Yeah, I want to clarify that when my colleague brought up Mickens, are we alleging, or are you alleging there was a conflict of interest, or alleging that the court was erroneous to find there was not ineffective assistance of counsel, or what are we really looking at here? Because I see a difference between whether there was a conflict that required new counsel and whether that conflict was based on ineffective assistance.
My allegation is that the district court held a hearing on the merits of my client's ineffective assistance of counsel claim, but at that time,
So
the attorney was testifying against my client, which is inherently a conflict of interest.
So you're saying that the questioning was not to uncover or discern whether a substantial conflict existed, but rather to ascertain whether the standard of care for a criminal defense attorney had been met.
That's right. And when they crossed that threshold to now delving into the merits, this wasn't just to try to figure out whether there was a conflict of, with regard to the relationship or something like that. This was, we are delving into the merits of this client's claims, factual claims, and this attorney is testifying against this client.
And
That's the conflict.
doesn't it seem that counsel recognized that when she told the court that she thought probably new counsel needed to be appointed? I mean, isn't that in essence what she said?
Which is what defense attorneys should do. Your Honor, you're asking me now to change my role from one of loyalty to my client to witness, and I can't do both.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. Regarding the lesser included offense instruction, there is nothing here that should firmly convince this court that the jury would have reached a different verdict if the lesser would have been given. This was one ongoing continuous act. He didn't stop and form a different intent in the middle of the touching. He had the same intent the entire time. Regardless of when she woke up, there was one intentional touching here, ongoing, and that intentional touching was sufficient to uphold a sexual battery conviction, aggravated sexual battery conviction. On the IAC claim, the court here was in a weird position. It was a motion to dismiss counsel for ineffective assistance of counsel. To dismiss counsel is usually, I just want new counsel. He wanted new counsel for sentencing, is the way I read the motion. When you want new counsel, what the court ordinarily does is hold a hearing to figure out if there's some kind of conflict with counsel, whether or not counsel can continue to represent this client, because the client doesn't have the right to the counsel of their choice, they have the right to effective counsel. The court held that hearing in this case, tried to figure out what exactly the guy was claiming, and then said, no, you don't need new counsel, we're proceeding with sentencing. On the ineffective assistance of counsel claim, if this can't be a 1507, he's not under custody of sentence. So that can't even really be alleged. It could be a motion for new trial, but he never asked for a new trial. He asked for new counsel. Assuming even if it was a motion for new trial, all the claims here could have been summarily dismissed. They could have been dismissed without any kind of hearing whatsoever. And if they could have been dismissed without any hearing whatsoever, because there was no deficient performance here, there certainly wasn't anything he alleged was prejudicial. In fact, it was all conclusory. He never said what these witnesses would have actually said, even when he was given the chance to expand. If they never were required to have a hearing, the fact that something happened wrong at the hearing is harmless.
I know you're coming in to this at the
Yep.
11th hour, but my understanding factually is that defendant believed there were witnesses that could corroborate his statement that the victim who he had talked to at the bar had invited him over to the house. And the defense counsel said, well, I talked to that witness, and that witness didn't say that. And defendant then says, well, my mother and someone else talked to that witness, and they did say that. So why isn't that specific witnesses on a specific topic that goes to a specific element of the crime with which he was charged, the burglary, and why isn't that difference, factual difference of conflict?
Well, the actual motion, he did not set forth any kind of detail like that. So I'm saying on the actual motion, there never should have been a hearing on whether or not counsel was ineffective. The only hearing that should have happened here was whether or not there was a conflict to allow this counsel to continue to represent the defendant at sentencing. Since there wasn't,
How do you say that when counsel suggested to the court that there probably needed to be new counsel? I mean, that it appears that the attorney was recognizing a conflict.
I don't know if she was, well, she, I believe, was advocating for her client at that point. That shows actually that there wasn't a conflict. She was saying, my client wants new counsel, I agree, he can have new counsel. That is kind of the opposite of a conflict, but I agree this whole thing is kind of a mess. But what we don't want is every single defendant to come in and say, my counsel was ineffective, so I get a new counsel. They could do it pre-hiring, they could do it pre-trial, they could do it after trial, and every single time do we really have to appoint new counsel to figure out counsel is ineffective? I don't know the answer to that. I'm hoping not. I'm hoping that we will not create yet another delay tactic on the part of defendants where all they can say is, well, I think my counsel was ineffective, so I get new counsel.
But if there's an IAC claim, isn't the best time to figure that out immediately after trial and before sentencing? I mean, aren't we really helping the whole system if we say during that period where it's a timely motion for new trial, potentially, that we get to the bottom of the IAC claim?
If you limit it to post-trial, sure, then it's not as much of a delay tactic. They can just raise it at any time. And I guess they can't really raise an effective counsel when trial hasn't even happened. I see your point that, yes, it would have been, if they had the full-blown IAC hearing, that would have been a resolution. But he wasn't asking for a new trial. I think that's
Is that
part of
clear?
the confusion.
I mean, it's not clear that he is, but
Right.
is it clear that he is not asking for a new trial? I mean, some of his language is very ambiguous, and obviously it's all aimed at concerns he has about the way he was represented during trial.
Right, but I mean, the motion was titled motion to dismiss. It sounded the whole time he was arguing to me, and maybe I'm misreading, but it looks like he just wanted new counsel for sentencing. And in which case, I don't think anything of note happened at sentencing that harmed him. He can still do his KSA 60-1507, try and get his counsel, have the full hearing still. You guys could even do a band waiver remand to determine whether or not counsel was effective. I know this is procedurally a mess. We just don't want more delay tactics on the parts of the defendant. And the district court here did the best it could, I think. I respectfully ask that you affirm the convictions in the sentence in this case.
Any more questions? Thank you, counsel.
Thank you.
I don't have anything else in response unless the court has questions.
Counsel, how would you respond to opposing counsel's statement or really question about if this court grants you the relief you're seeking here, does that create a scenario where all a defendant has to do is to allege post-conviction but pre-sentencing, my counsel was ineffective, and then there's sort of a per se rule that then they automatically get new counsel? Is that the result of what you're asking for?
I don't think necessarily, and my only hesitation here is I'm sort of trying to.
It's close, isn't it?
Yeah, I'm trying to put this together with some of the other recent court cases from this court. Because certainly, and when I briefed this case, I suggested, I think the district court at that time could have said, I'm just not going to hear this claim. I'm just going to find it not sort of ripe at this point to hear an ineffective assistance of
So
trial
maybe
counsel
we have
claim.
just sort of a binary choice that district courts face, either dismiss it on the face of the pleading or appoint new counsel.
Or appoint new counsel.
But
I
there's no in
certainly can
between.
agree with that. Whether or not the district court has the ability to sort of to do that first part, I need to read this court's cases like Sharkey and Stovall a little bit closer to know that. There are jurisdictions that apply that very rule.
I don't understand that. I mean, and this has been the tension that we've had in these more recent cases, because we're going to tag the district court judge if he doesn't ask the question. We're going to say you didn't inquire. We've even got language that says if you don't appropriately inquire. And I don't even understand what that is. It's sort of like you can ask, if you don't ask 4 questions and you only ask 3, you didn't appropriately inquire. It seems to, I'm trying to get back to Justice Stiegel's question, which is, aren't we just at a per se rule that when the defendant holds up his hand, we got to get a new lawyer? Because there can't be any other answer. And just to continue this, part of my frustration here is, so the judge does what we've told him to do for decades, inquire. But are we saying the district court judge can't inquire of counsel? Because then if counsel's giving an answer, and that answer is something the defendant doesn't want, then we got a conflict. And so now we got to appoint a lawyer because there's a conflict. I think the trial judge is being put in a terrible position. And so I need to know from you whether the answer is only a per se rule that you get a lawyer, or that there's something less than that, and if so, what is it?
I think the answer to these questions has to do with what is the nature of what the court's deciding. If the court's deciding, and we see this when we have pretrial, during trial, post-trial, whatever, if it's just a sort of I want a different attorney because I have a conflict with my attorney, we're breakdown in communication, breakdown in relationship, etc., that's the kind of case that you've talked about before, that the court has to make an inquiry. But in this case, where the court's making investigation and having a hearing on the merits of the claim, the factual claims of the defendant regarding ineffective assistance of counsel, then yeah, I think there's a per se rule that any time a judge is reaching the merits of claims of ineffective assistance of counsel of an attorney, that attorney can't be acting as an attorney in that situation. So it depends on what is the district court deciding. So when I have that client who before trial says, I want a new attorney, there's the inquiry that this court has required, and that's appropriate.
And the standard is justifiable dissatisfaction.
Yeah.
It's not a Strickland test. It's justifiable dissatisfaction. And what you're saying is the inquiry as to whether the dissatisfaction is justified doesn't require a determination under Strickland whether the defense counsel met the standard of care that we placed on him.
That's right. This is not a case of a client just expressing dissatisfaction with their attorney. This is a client who made specific claims of failure of their attorney to do things during a trial. That sounds like an ineffective assistance to counsel claim to me. And yes, I would say there should be a per se rule that defense attorneys cannot represent their clients regarding their own ineffectiveness, at least unless they're ready to concede it. And even then, I'm not sure.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement.